10:25 till, right? So at 10:25, we'll unmute, and at that point, anyone watching online will be able to also hear anything that's happening in the courtroom. So we just ask that you keep conversation relevant at that point. Also, counsel, when you're up here, this microphone, please don't place anything over it. It'll be muffled and it'll create feedback. So if you can please just help us with that. We have court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. This is S-1-SC-39225, Aztec Municipal Schools versus Cardenas. Can I have entries of appearance, please?
Your Honor, Josh Collins, retrieving background on behalf of Aztec Municipal.
Thank you. Mr. Collins, it appears that you have asked for 10 minutes for your argument in chief and reserved 20 minutes for rebuttal. Is that correct?
Yes, Your Honor.
And if you all can't hear, we have a new audio system that they are struggling with, so that feedback hopefully will adjust itself as we move along. All right. Mr. Collins, you can proceed.
Thank you, Your Honor. May it please the court. The Court of Appeals created and improperly applied a new non-statutory category of impairment in deciding categories of impairment for purposes of equal protection. Specifically, the Court of Appeals created a category called secondary physical impairment when trying to compare whether similarly situated workers with a secondary mental impairment are treated disparately. This improper creation of a new category hinders the ability to do an equal protection analysis for the parties because we don't know what class of worker we're comparing, because the legislature does not recognize a secondary physical impairment.
Well, you do know you're comparing a mental impairment and a physical impairment. And even though they called it a different name, those subsequent physical injuries have always been compensable. So I find it hard to believe that we don't know what we're comparing here. It's the difference between someone who gets a subsequent physical injury and someone who gets a secondary mental impairment. I mean, isn't it? They've always been compensable.
Your Honor, there is no dispute that subsequent or latent injuries, whether mental or physical, are compensable under the Act.
Mm-hmm. But it's the fact that we've arbitrarily capped one and not capped the other. So put the semantics aside from the Court of Appeals opinion. I think it is distracting from the actual analysis in this case. I understand that the judge below was using that as shorthand to try and describe the problem that the panel saw. But I think those semantics really do distract here, because under our statutory structure, if you have a primary physical injury that results in a related subsequent physical injury, my elbows hurt, I overcompensate, I hurt my shoulder. And we analyze each of those injuries distinctly, whether they're scheduled or unscheduled, but we analyze them differently. The statute for mental impairment that is related to the primary physical injury arbitrarily caps that to the physical injury. And that rather than having two independent analyses, both for subsequent physical and subsequent mental, that's the equal protection problem, is that the analysis isn't distinct, and it's quite antiquated. And as I'll point out as well, it's based on this fundamental misunderstanding about the length and duration of mental injury. And I think that's what gave rise to it, this arbitrary distinction of secondary medical being tethered to the physical. But it's the fact that you have no analysis happening for the related subsequent mental injury that makes it, that's the equal protection problem here. Address that.
Yes, Your Honor. and I'll start kind of maybe with the latter bit. What then we are addressing is no longer 41 and 42. We are now addressing 24B and C. And we are addressing the difference between secondary mental impairment, which is defined by the legislature, and primary mental impairment, which is defined by the legislature. And this is the concern, is that in an analysis of how 41 and 42 treat workers with different injuries, we're now looking to address different levels of mental impairment, but without having the opportunity to create the proper record and to argue those facts.
No, we're not addressing B and C. We're not, are you saying we're then distinguishing between primary mental impairment and secondary mental impairment?
In effect,
I disagree. I think we're all on the same page, or at least the Chief Justice and I. It's basically a non-scheduled, mental impairment's nowhere, it's not a scheduled injury, right? I mean, you'd agree with that. It's nowhere in the schedule, which means it's a whole person injury. And we're not, and there's certain circumstances that subsection C is being capped at a scheduled injury amount of benefits. It's being treated differently than a physical injury. It's the comparison between a mental impairment you get as a result of the original physical injury and a physical impairment you get as a result of the original physical injury. And so to me, we're not comparing primary and secondary mental impairment. It is physical versus mental. We're treating them differently. Even though a mental impairment would be a whole person injury that takes just as long to heal and treat, that our legislature must define, they didn't put it in the scheduled injury, as any other whole person injury.
yes, Your Honor, and I would say that the legislator put it in the schedule through tying it in 41 and 42. They have explicitly tethered it to the underlying injury. And so I understand that then that moves not to whether or not it's disparate treatment, but whether or not there's a substantial relationship.
How can you say that though, if they didn't put it in the schedule, it's not in the schedule, and if it's connected to a back injury or something else, it's not capped at scheduled injury benefits. It's tethered to whatever the physical injury is. So there's circumstances where it's not at all being treated like a scheduled injury. It just happens to be which injury the person originally got. It's either, did you get a knee injury and it's scheduled, or did you get a back injury and it's not?
Correct, Your Honor. And we wouldn't argue that different injuries are treated differently, and that is disparate treatment. And then moving to whether or not there's a substantial relationship, we would argue that the big concern in the Court of Appeals analysis is that they address Breen as having already decided these. But Breen dealt with primary mental impairment. In fact, Breen, in discussing whether or not there's a substantial relationship, in order for the government to treat different injuries differently, they looked at the higher evidentiary standard required for primary mental in order to determine whether or not the government interest is being protected to, again, keep the work comp system financially viable. The Court of Appeals did not do that analysis. The Court of Appeals adopted Breen's analysis in primary mental and then has now applied it to secondary mental. Secondary mental has no evidentiary safeguard that primary mental does. In effect, what the worker is arguing in this case is for all mental impairments to be treated equally at 500 weeks, with one having a sufficiently higher safeguard, with the other not having any higher evidentiary.
But if it's unscheduled, the work comp judge then has to perform analysis that is then reviewable about the nature and the scope of the mental impairment and make a decision. Because I agree, there is a difference between situational depression and long-lasting PTSD. But the judge is given and directed to conduct that analysis for the unscheduled injury. So we're just treating the subsequent mental injury because it's unscheduled. It should be treated the same as the subsequent physical injury. This arbitrary distinction between physical injury and mental injury is an antiquated, outmoded form of analysis, and it gives rise here to disparate treatment because we're analyzing subsequent physical injury on its own merit. And we're not analyzing subsequent related mental injury on its own merit. That's disparate treatment. How do you get around that problem of one is analyzed and one is not?
Well, Your Honor, I would say that using the logic of Gold, and again, we're not arguing that Gold is persuasive, but the logic of the court in Gold discusses the contours of Breen. And in Gold, the court recognized that Breen's contours do not extend to treating different injuries differently. A knee, whether mental or physical, is treated different than a back, whether mental or physical.
But there's an individualized analysis of what that is. Here, we're just saying, we don't care what kind of mental injury. They're all the same. We don't care. We're going to tether it to the knee. We don't do that in physical. The injury to the knee has its own path. The subsequent related injury to the hip has its own path. We're not doing that here, and that's where your argument, I think, breaks down.
Your Honor, I see I'm short on time, and I don't know, should I say? for
You
rebuttal?
should answer the question, and then we'll.
Okay, and I would say one argument to address on rebuttal is an antiquated system, and that might be, but those resources are best left for the legislature to determine if we want to address mental health differently going forward.
I don't disagree, but you're not addressing the equal protection problem in the individual analysis of what the injury is.
Yes, Your Honor, I would say nowhere does a secondary mental impairment, is it deprived of a healthcare provider or any other of the evidentiary or litigation procedures. A worker is never deprived of those in order to flush out and determine and address and diagnose and treat individually, just as you would a knee that turns into
No,
a hip.
because you're putting a cap on what's available in terms of the work comp structure. So I injure my elbow. And as a result, so, maybe something that we would consider small, injure my elbow, but then I can't, as a result, breastfeed my child. Huge potential mental, consequences to that. Capping my recovery for this very significant mental trauma to something that might seem de minimis, the elbow, that doesn't make sense. We're not doing an individualized analysis of what the mental injury is as an unscheduled injury.
Correct, and this is where I will say we are rubbing up against the difference between primary mental and secondary mental, and whether or not you can have a latent developed primary mental with a heightened safeguard, and whether or not a worker is free to pursue that as a primary mental injury.
That's not this case.
Oh, sorry. Go ahead.
Yeah, that's not even before the court.
But you're talking about the proof, and I'm talking about the impairment. The impairment after being diagnosed by a doctor, and I assuming the AMA guides still apply. It's the impairment. It's the resulting impairment, which could be equivalent for a primary and a secondary. We're not comparing those two. It's the impairment after the person has reached MMI that the person has, and whether they're getting treated the same. And someone who gets a subsequent physical injury and someone who gets a secondary mental impairment, even though the impairment may be the same degree, they may suffer just as long. They're being treated differently. It's the impairment I'm focused on, not everything that comes before.
And should I answer at rebuttal or answer now, Your Honor?
I don't think there was a question, so I'm going to ask you to go
I'm sometimes
ahead.
bad about that.
Oh, no, sorry.
No, you're fair. You're doing the right thing.
Okay.
Thank you.
You can cogitate on that while Mr. Titus makes his presentation.
Thank you for being heard on what I think is a very important part of our compact. And I wish I could write as eloquently as Judge Maez did in Breen back in 2005 and Judge O'Hallam did last year in the Court of Appeals. I think both of those are spot on. They recognize New Mexico has been at the forefront of affording greater protection for mental disabilities. And Judge Maez goes through the long history of how mental disabilities have been treated differently and how that cannot be consistent with the equal protection law in our state. Breen was decided under the law before the 2015 amendments, and so was Gold. And so really, this is the first time the court has the ability to make clear that under the amendments that happened after Breen, that the principles of Breen still apply, and that they should apply equally to the secondary mental. I think the justices have spot on correctly. There are two ways, I think, to get to a mental impairment. And this focus on, well, there's got to be some difference to affect the higher standard for a primary to somehow protect that. And I don't think that's true. The reason, and if you go through Breen, they make it very clear that it's okay in the primary side to make sure that we have these extra protections that make sure that it comes from a traumatic event and the like, is because the law does not recognize mental impairment that arises gradually over time. There has to be a specific and isolated event. And that's why we have the greater protection in primary. We don't need that in secondary because we have a specific event, and that is the physical injury itself. So you have two paths to get to what is a compensable mental impairment.
So, Mr. Curtis, the trouble I have with Judge O'Hallam's opinion is that I understand what she was trying to do, create this, create shorthand for, I think, what you are describing here. But I think the opinion itself creates confusion. We can see it in the briefing, we can see it in the argument, because she said secondary mental, trying to parse the two. Even though on the physical side, we don't have primary and secondary. We have subsequent related. And so should this court write to clarify that so that there isn't this confusion? Because I think as kind as you are being to Judge O'Hallam, I think she muddied the water with this idea of secondary mental impairment when we don't have the parallel under physical. So shouldn't we write to clarify that?
And I think it's always appropriate to clarify. I think you were spot on when you started that it's a matter of semantics, and it's a term that is not in the statute. But if she would have said for the subsequent injuries that happen consistent with the BACA line of cases, and in the reply brief to this court, the employer insurer agrees BACA is good law. We're not asking to overturn it. And so really what we need to do is make sure that consistent with the BACA line of cases, if the subsequent, let's use that word, I think that's the word they use in the reply brief, if the subsequent impairment that arises later is a mental one, it is treated like they do in BACA. BACA says if you give rise to, in that case, had a knee injury, limped around, caused the other side to be surgically repaired, was on crutches, and then had shoulders. And it's really clear from BACA, the other knee is a scheduled injury, not because it's the original, but because it's a scheduled injury. But the shoulders are not on the schedule, and they are treated as whole person 500-week impairments. And that's simply, I think, the end result of where this is all going, whether you semantically call it a subsequent secondary. I mean, I think we're all trying to get to the same place, and that is treating the folks with mental impairments the same as the physical. And for this tethering argument really bothers me because, and I think it was mentioned, once we get to the compensability, then both have, through maximum improvement, total disability at the same amount. And then at the time of maximum medical improvement, then you look at the impairment. Well, if the impairment in the AMA guide is 15%, does it really matter whether it's for a primary or secondary? Shouldn't the effect as defined in the guides be that it's the same loss of physical function? And so when you start tying that then to the scheduled injury section, what makes a secondary subsequent, or however we want to clarify it, mental impairment less worthy if it comes from a finger, if it comes from a knee, if it comes from a partial loss of use of a knee, or what about if you have an amputation? I mean, one of the things that struck me is one of the arguments was, well, because it's a primary, it somehow has to be longer lasting, meeting with more treatment, more of a traumatic event. Well, I don't think that's true. Actually, I think the subsequent or secondary mental impairments can be more disabling because they not only have the mental side, now they also have the physical, which can vary, as I said, from a finger to perhaps an amputation.
So, Mr. I just want to ask about something that is at least alluded to in the briefing. I haven't heard it yet today. This idea from the Work Comp Administration that going down the path that you describe will undercut the predictable and formulaic nature of work comp and somehow affect the fund.
Well, both the Breen Court and Judge O'Hallam dismissed that outright. There's no evidence. We don't know. And I think the language talks about these old notions that might somehow be true. We can't make a decision based on no evidence. And there's
You have a lot of experience in work,
yes, ma'am.
more than probably the five of us combined. From your perspective, understanding that what's lacking in the record, but from your perspective, what about having the same path for mental injury as we do for physical injury that's subsequent and related? What about that would make this less predictable or less formulaic?
I don't see how it could. I mean, probably the insurance adjuster in Baca thought they had a knee injury that was going to be treated as 150 weeks under the schedule at maximum improvement and had no idea that it might lead to another scheduled injury in a couple of whole persons. That's a potential in every case. Now, does it happen very often? No, it does not. We do get secondary mentals in some cases. I would be willing to guess in the cases I do, it's 5% or less. And so I don't see that it would be a wave of these cases that would make unpredictable what might be payable under a case. I mean, there's always going to be something that can arise later, and it depends on the nature of the original injury and in some ways the nature of what that particular worker brought to the workplace to start with. Okay, because
does it tie to the standard applied in an equal protection analysis? Was Breen saying what the workers' comp judge said is fine for purposes of rational basis but not intermediate scrutiny? Or are you just saying there's not enough evidence here to establish one standard or the other?
well, I'm saying there's no evidence.
Okay.
And so, but I do believe that intermediate, because of the sensitive nature of the class, is the appropriate analysis.
Okay, so my follow-up question is, in your view, does Breen speak to that standard and what the workers' compensation administration is arguing?
Yes, they do. And if I could find the quotes, which I probably won't quickly, but I think Breen talks about the financial viability of the Workers' Comp Act and the employer's limited liability and predictability of costs, and that those are dismissed basically as self-interest of the employer-insurer in Breen paragraphs 26, 34, and 37, in Judge O'Hallam in paragraphs 24 through 26. And I think that's absolutely appropriate because that, again, goes back to those old notions about, well, we can't trust mental disabilities. We worry about what might happen. But really, that does not allow, under an equal protection analysis, the employer-insurer, who now has the burden to show that there's an important governmental interest that's significant in this case to overcome discrimination. But one of the things that always troubled me about Gold is Gold says in paragraph 15, this is discrimination. This is not the discrimination that was prohibited in Breen. And I went back and did a lot of work to find out, and I looked at the petition to this Supreme Court out of Gold, and it was presented basically that Breen has already decided this issue. It's a mental impairment, therefore, that's all we have to do. And there was no real analysis like Judge O'Hallam did in this case, trying to look at.
Did she do that much more? She just kind of said Breen. They haven't come up with Breen Plus. I mean, that to me is 27, 28. I mean, that's kind of what one of my issues is. mean, I would like to know what else I'm not criticizing the opinion, but I was curious about, there wasn't a whole lot of work through on intermediate scrutiny. She just kind of said, well, we addressed it in Breen. They didn't come up with anything else. And whatever they come up with, I kind of think is rational basis. But what else did she?
Well, here's the problem, as I see it. If this is an equal protection analysis under intermediate scrutiny, then the employer-insurer has the burden.
Right.
They didn't put anything in the record at the Work Comp Administration. They didn't attempt to put anything in the record at the Court of Appeals, and they haven't done that here. And so, what are we left with? I mean, there's nothing to analyze because they haven't even attempted to take on that burden. In fact, as I read the briefs, they really don't want to have this as an analysis under the Equal Protection Clause because I think they realized early on that's not a winner. That's why I think we get these two issues that were raised in the petition. And if we limit what we're talking about in this appeal to only those two issues, I mean, the first one is dismissed right out of hand because what is the name? Call it subsequent, call it secondary, call it whatever it is, call it the Baca line of cases. I mean, that is not a reason to not do the analysis.
So, Mr. Titus, my question is, you said that you believe intermediate scrutiny applies as opposed to rational basis. Can you give me a little bit more explanation of that?
I think the explanation comes from the history that Judge Maes does in Breen as to mental disabilities being a sensitive class. And once that determination is made, the sensitive class becomes the stepping stone for why it is intermediate scrutiny versus rational basis.
Your position is that Breen resolves.
Well, I think that the same analysis is here. I suppose, Breen is not absolutely on point because it did the primary, but I don't think there's a difference between people with mental disabilities that might be primary under a compact versus secondary. There are people with mental disabilities, which she talks about generally in the history of that they have gone through in being underrepresented and discriminated against over time. And I think all that history applies here, and there's nothing to suggest that it doesn't. So,
Do you feel that this distinction satisfies rational basis?
well, I didn't really do a lot because the employer-insurer never said this should be a rational basis test, and this is how we can justify it under the rational basis. They didn't get there. And that's why I think it's important to take a look at this case on the issues that they raised to get to this court. And so I think we'd have to go back and take a look at a whole different set of briefing if we're going to start looking at it under a rational basis test. And so,
Well, Mr. Titus, they're arguing that it's the predictability and the employer's ability to determine what their liability is going to be that is the reason behind it. Is that rationally related to
I don't think so,
legislation and the
because
distinction? Why not?
I don't think so, and here's the reason. It doesn't have a rational relationship to the particular disability. It is no less or no more predictable than the line of subsequent injuries that.
But I think the question is the rational relationship, is the distinction between mental and physical rationally related to the purpose the legislature has put forth that it's predictable, that needs to be predictable?
I don't think so, and I don't know how you can get there because I don't know how you parse that distinction that we don't worry about the predictability of a physical injury, but we do somehow worry about the predictability of a mental injury, which quite frankly is going to happen way, way less than a physical injury. For instance, I have a lot of cases where a guy gets a knee injury, starts limping around, next thing, he's got a low back. That is way more predictable than a subsequent mental impairment.
But isn't it also, in my mind, if a secondary mental impairment is always treated as a whole person, because it's not in the schedule, then isn't it more predictable to say it's always going to be treated as a whole person? It's always going to be subject to the 500 weeks, as
Yeah.
opposed to it might be 150 weeks for this case. It might be 10 weeks for this case. It might be, so do you
I
have
think you're absolutely right. And here's how it could muddy the water and even make it more unpredictable, because I have these cases all the time as well. Sometimes you just don't have one injury. It's not always a guy picked something up and injured his back or he wrenched his knee. Sometimes we have car wrecks, people on drilling rigs. They have a multiplicity of injuries. They have a back, they have a leg, they have an arm. I mean, they're hurt bad. Now what are we going to tie it to? Which is the original injury that we would tether it to? Would we tether it to the knee, to the back, to the arm? I mean, that would make it even more unpredictable.
So isn't this really, from the employer insurer's perspective, the either rational basis or the important government interest? In the end, without having any evidence in the record, it's really about the cost. I mean, I don't get the argument about predictability and the other. In the end, isn't that what we're all talking about here?
Well, probably.
Put it bluntly.
I mean, and I think as the previous opinions talked about, it boils down to self-interest. I mean, what's it going to cost us, frankly? But how do we know what that is? And how do we know that that's somehow, where's the line? When does it become inappropriate? Because we don't have any evidence to determine that. So, I mean, if they have the burden to show, then they don't have any evidence to make that burden. So that's the point I want to stay with. Let's see here. I think I've covered most of the points I wanted to deal with. And there's one last one that is very troubling in this case, and that is we've been 4 years since March of 19, 4 years and 4 months on appeal. The comp judge has stayed all determinations in this case. My client has ongoing medical issues, didn't get them heard. My client's not here today because she had another surgery on this same knee on July the 5th and is home convalescing, hopefully watching on live stream. And so we would like the opinion to also make clear that there should not be an automatic stay in these cases. There's no reason why issues concerning my client's medical care should be held up while we're determining how many weeks of benefits she should get. So
Is that in the, I actually didn't.
it was not briefed.
No, I understand. It's in the workers' compensation order that it stayed, or is there a separate?
No, in fact, we filed two subsequent, we filed a complaint that was ordered that would not be heard, and we filed a request for an IME that was ordered that would not be heard.
So none of the medical care is being addressed at this point?
And not for a long time.
But is there an order staying somewhere in the record?
Not in this record. So unless it comes from below, and probably those orders were after the record proper was transmitted. So
Thank you.
I don't think that that's probably going to be what's before you, but that is a practical issue that we hope that could be dealt with. Just in wrapping up, I think that what makes this compelling for this court to act is this: we need to recognize the long history of, let me find my note, of how mental disability has been treated. These people are the most vulnerable. They're frequently discounted as liars or crazy. They're isolated and denied housing, employment, health services. They're severely disadvantaged socially, economically, vocationally. And as Judge Maya's very eloquently said, they're usually the most negatively perceived of all the disabilities and susceptible to baseless stereotyping that is motivated and perpetuated more subtle forms of discrimination. And so these are the most vulnerable amongst the folks that Compact tries to address. The statute in 5251, the mission statement of the workers' compensation, all state that the quick and efficient delivery of benefits both indemnity and medical to the workers, is what we're to focus on. And so I believe that that provides further evidence that this court should make clear for, under the statute as is written right now at least, that primary mental and secondary mental are not going to be treated differently. And they're not going to be treated differently than the BACA line of cases where physical impairments arise later. And that is the only way to make this the most predictable, to allow the judges not to get tied up in these issues that we've been talking about, but treat all of the cases the same. And so I think it was very clear in Green, footnote 2, and as Justice Zamora indicated, the legislature created an exclusive list of scheduled injuries, and the legislature did not include mental impairments on that list. And when they amended the statute in 2015, could they have put a secondary on the list? I don't know. That might have been an equal protection violation as well, but that's not what we're here to talk about. They didn't put it on there. And as I mentioned, I think there's two paths to a mental impairment. And once you get to a compensable mental impairment, they should be treated the same. And they should not be treated differently than a similarly situated physical impairment. And
So you're not making any argument that somehow your burden before the workers' comp is any different or lowered?
no, I mean, we still have to come forward with evidence. We had, as we did in this case, there's a psychologist that gave an opinion as to diagnosis, as to when they were at maximum improvement, whether or not there was an impairment. That's no different than we do with a physical medicine doctor on a knee, a back, or any other injury. And so the only question is, how many weeks are they going to get paid? I mean, otherwise, there's no difference.
Thank you.
Thank you very much. Look forward to your decision.
Mr. Collins. And I'm going to jump in right out of the gate.
Okay, sounds good.
So it's picking up on the colloquy between Justice Zamora and Mr. Titus, which is potentially kind of an absurdity that I need you to navigate for me. So points out that if you have a worker who has a multitude of injuries, say there's an oil rig explosion, so injuries all over. What's the primary injury that then is going to be, that dictates what the time frame is for the mental injury?
The greatest.
How is that evident from the work comp statute?
So in your hypothetical, I presume we do have a whole person injury. Is that correct?
No, you've got an injury to the shoulder, you've got an injury to the knee, you have a burn on the cheek, whatever, say they're all scheduled injuries, but there's more than one. How does that, which one are you going to rely on to say, well, that's the maximum recovery for mental illness?
Nothing in 41 or 42 caps it to a lower amount. So I think you're able to read those two statutes to know that the largest scheduled injury will be the tether.
What says that in the statute? And then the follow-up question is this idea of predictability and concerns about, cost and expense kind of fall by the wayside if we're just, somebody's randomly picking which one is going to control the recovery.
Yes. Your Honor, first to address the first question, 41 and 42 do have a 42.4, for example, says the maximum period is the maximum period allowable for the physical impairment. So
which physical impairment's driving the boat? It doesn't say you pick the one that's the longest when there are 3. Or can they say, well, there's 3, and so we're going to take the maximum impairment for each 3 and total them together? Well, then that's going to be more than 500 weeks. And so it undercuts your fear about the collapse of the work comp system.
Certainly, Your Honor, I would say other case law dictates how stacked injuries are paid out.
But are you conceding then that if there were stacked injuries, that each one of those would be added together to yield something much greater for the related mental injury?
No, Your Honor.
You want it to be one.
Typically, we would pay out as one, with the stacks decreasing as the shorter injuries resolved. So as 15 weeks came and went, the impairment paid for 15 weeks would stop, but you would continue paying up until the 150 week, which would be the
So-
longest one.
Actually, this raised, now I'm even thinking of more possible confusion, because you're looking at 52-142-4. It says produced by the physical impairment. It doesn't even say the original physical injury. So presumably, if you had a subsequent physical impairment, could it be tethered to that as well? If there's a causation finding by the doctor?
Correct, Your Honor.
I mean, it doesn't say original physical injury. It could be actually the subsequent, right?
Correct.
Okay.
I would agree. So once all conditions are obtain MMI, then at that point, a benefit period is determined by the nature of the injury. And maybe this gets to the argument. The nature of the injury is never foregone in the analysis.
Well, certainly it is, because the nature of the injury being a mental injury in many, many myriad case will have no relationship whatsoever to the duration of the physical injury.
Correct, but Your Honor, I would say that the nature of the injury is never, either side never forgets or forgoes analysis of what body part is injured, whether or
No,
not
but
it isn't a mental injury.
Yeah, you're foregoing analysis because you're saying, well, it's the elbow gets X, and so the mental is X. There is no analysis of the mental injury. It's just being arbitrarily tethered to the physical injury.
And Your Honor, and maybe this is where I would say not arbitrarily tethered. I would move to the argument that it does meet the standard required for the disparate treatment. Conceding there is disparate treatment, then there's an important government interest.
Okay, you need to convince me on your important government interests, because
Rational basis,
I'm not
remedial.
buying it at all.
Yes, Your Honor. Intermediate scrutiny. We would concede it's intermediate scrutiny. Breen, first of all, expressly states that financial viability is a proper goal and an important interest. Breen indicates that fraud protection is an important interest.
This isn't about fraud. Let's focus on what this case is about. And if you're going to allege that mental injury equates with fraud, we've got a whole different problem here. So talk to me about the important governmental interest for treating mental injury disparately from physical injury.
And where in the record it's supported?
Okay, yes, Your Honors. Financial viability is expressly decided to be a.
Going back to Mr. Titus's point, you know, how are you haven't shown us that there's going to be any financial impact or change. You know, a physical injury could, if there are multiples that follow each other, could create a really long period and does not allow for the predictability that the statute talks about. How can you show us that a mental injury would be even worse?
Well, because it is now untethered to the underlying physical injury that is.
But where's the support that it would impact the system more severely than the physical injury, than when the way that it's analyzed now?
And I don't think it needs to be more than the physical. It'd just be an increase in any way is going to affect in some way the financial viability.
But you don't get to say my important government interest is this hypothetical, undemonstrated, oh, it might affect the viability of the fund. You have to give us more than the sky is falling without any support. So where in the record is your support that there are X number of claims based on mental impairment, and if you move those into the 500-week category, it will collapse the fund? Where is that in the record? It's not.
In Breen.
No, in the record, that is not, and Breen doesn't say this is going to collapse the system. It says that's something you can consider, but then you also have to prove it.
Yes, to see whether or not it's substantially related, but Breen does acknowledge that the financial viability is an important government interest. It's
But
not
I
just
think,
part-
what you're missing here, and correct me if I'm wrong, is Justice Vargas and the chief are making the point that there's no evidence in the record presented to demonstrate that this will have an adverse impact. All we have is argument and an assertion.
Yes, Your Honor, and I don't think the standard requires demonstration of an adverse impact, just whether or not the law, as the legislature wrote, is substantially related.
So you're saying that any time there's an intermediate scrutiny, there doesn't need to be proof in the record, the other side can just come and say, oh, the financial viability, they just have to assert it and that's sufficient? Or do you think there needs to be evidence in the record? We're talking about intermediate scrutiny here, and I'm just concerned about not requiring it's usually the government or whoever, whatever side's gonna say the sky's falling, not to have to support it in the record.
Well, Your Honor, I think, again, it may be the government interest of financial viability is established via Breen.
Yes,
But
the
in
interest.
the adverse impact is, I do not believe, part of the analysis. It's
But what if Mr. Titus had come to this argument with a study that said that if you interpret it this way, it's not going to have any significant impact on the financial viability of the system. And you get up and tell us, but the financial viability of the system is all you have to consider, even though all the evidence shows that that's not going to have any impact. You can't just get up and say that and we say, oh, you meet intermediate scrutiny, so that's fine, can we?
No, Your Honor, but I would defer to the legislature on the second part, is whether or not the act, their interest was enacted in the words of the act, which is wanting a higher evidentiary requirement for primary versus secondary.
So so you're saying that's the reason for the discrimination?
It's the relationship between the interest, what interest they were attempting to protect and how the means they went about protecting it or addressing it, whether or not it has an
Where do you
adverse.
draw that conclusion from the language in the statute or from legislative history, perhaps? If there is any, I'm not sure.
No, but I would say this, the Court of Appeals didn't do that analysis. They said it was brought up in Breen, and Breen doesn't matter, but that Breen was a primary mental, and
But you're not doing the analysis. That's why I'm asking, like, where in the statute and the history is, or the record, any of it, supports your important government interest instead of you just telling me what it is? It could be the statute, the legislative history, the record.
Again, Breen expressly says that the financial viability of the system is a sufficient governmental interest. And now we need to look at the relation between the
And
disparate
where
treatment.
have you demonstrated the relationship, if I'm going to take your argument at face value, what's the relationship between this, I'll call it a wonky analysis of mental impairment? How is that related to your concern that the fund is going to collapse if we put mental injury where it should be?
And I'm not saying the analysis is that the fund will collapse. I'm saying the analysis is that the predictability will be taken away, and that
The predictability is not the same thing as financial collapse. You're telling me the important government interest is money, 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 money. And then I ask you, well, how is that related? And you say, oh, it's predictability. Those are not the same thing. Predictability, to me, is not changed by any of this. You regularly have unscheduled physical injuries. They're still capped. You regularly have cases where there's a cascade over time of injury, not any different with mental injury. So the predictability to me doesn't change, and predictability and fiscal are not the same thing.
and maybe predictability, I understand workers' argument is it will be predictable and that every mental injury will be a fine, virgin, weak case, which is true. There's some sense of predictability. But now we are undoing the difference between 24B and 24C through 42 and 41. It's expressly what worker has asked for in their argument, to treat both the same, to give them both 500.
Because it's an equal protection violation.
And
If you have an unscheduled injury, and if we treat mental injury and subsequent physical injury the same way, it's predictable.
correct, and this goes back to whether or not there's a
And
government
if you
interest.
don't, it's disparate treatment, and you're still not answering the question about what's the important governmental interest other than to baldly say it has a financial impact. You don't get to just baldly say it.
And maybe, Your Honor, I'm misunderstanding how Breen indicating.
It can say that is a consideration, but you still have to prove it. You don't get to just baldly say the sky is turquoise versus the sky is red. I mean, you got to give more to it.
Can I add to that?
Yeah.
In Rodriguez, which held the work of the farm laborers exemption unconstitutional, Justice Chavez says this: under intermediate scrutiny, the party supporting the legislation must show that it is substantially related to an important governmental interest. It doesn't say that you can just simply assert it. You must show, you must demonstrate that it's related to an important governmental interest. Bring in an adjuster, bring in somebody, bring in some statistics, bring in something about the premiums that are paid versus and how this would affect differently than physical injuries. But we don't have any of that.
Your Honor, maybe
And I want to make sure that I'm stating in a different
Exactly.
way what the
Mhm.
chief is
Yeah.
saying.
and the substantial relationship is the second part, maybe not the primary, and maybe that's where I'm mistaking. I understand Breen establishes the first part of the analysis. Is there an important government interest? Breen says, yes, these are important government
And then I
interests.
asked you the follow-up question and you said predictability. You said nothing about the financial. You say the important government interest is money. And then when you say, how's it rationally related? You say predictability. They're not the same thing. So what is the relationship of this important government interest, which is money, to the system that's set up?
And it is a way to, the predictability is separating primary versus secondary impairments from 500 weeks to something less. It could obviously vary depending on the nature of the injury, but it's not undoing the relationship. There's no other way.
So any impairment, your argument that the logical tether of that is any impairment, mental impairment, any impairment to the fiscal health of the fund, any is enough. Well, every time there's a claim that's substantiated, there's a depletion of the fund because there's payout. So you can't make, I don't see the logical path for that argument. There's still a cap on unscheduled injury. So this is not, now you're going to get payout for the rest of your life. There's still a cap. So logically, you're arguing that any additional impairment is rationally related to an important government interest, which then would collapse the work comp.
I would say giving deference to the way the statute is written at first to see whether or not there are different injuries need to be treated differently and some less than others versus just
There's no open-endedness to this. There's still an end of the road. So you're saying anything that is, you're trying to tether important, the importance of the fiscal health of the fund to predictability. And then you say, well, the predictability is we're not going to have to pay more. So under that theory, any increase in payment would justify the government's end here. How do you get there?
if it's substantially related. And this is the analysis that wasn't done by the Court of Appeals to see all their alternative ways in which to tether.
That's your,
Which they
burden.
That's your burden.
So I know, I understand it. I don't know if they had anything to write about it. I'm wondering the argument.
And I would reference Romero and Chavez, both of which, when the constitutionality of 24B and C, and 143, the schedule itself, because this is the same thing. Why is a knee not paid as much as an ankle? You know, why not just pay them all the same? Those survived. Those survived intermediate scrutiny. So I would say it's the same situation here, where there is no other way to accomplish the legislature's purpose, which is to tie secondary mental to the underlying injury. There's not a procedure or a process or an evidentiary way in which to do it. It just needs to be done expressly. And that's what the government has done in this situation.
In a way that I think you're going to probably hear violates equal protection. Just because the legislature says that that's how they're going to do something doesn't wash away the constitutional analysis.
Correct, understood. And this is, but we would say the Court of Appeals did not do that analysis. They adopted primary mental analysis.
What was your argument to the Court of Appeals that they had to look at that the statute is substantially related to the government interest?
Yes, Your Honor, the same as Breen.
So you just baldly stated our significant governmental interest is the fiscal,
Correct.
just like you're doing here.
Yes, but in Breen, it was a primary mental.
But let me ask you, you're so focused on that, and I understand the burden of proof is different between a primary and a secondary, but the impairment isn't. And under both circumstances, the worker has to prove through medical testimony supported by the AMA guidelines that the impairment is what the impairment is. So people with equal impairments should get mental impairments. I don't understand why they'd be paid differently. The heightened burden of proof is because it's an injury like getting shot at work. It's something traumatic that is connected. It is the injury related to the accident, whereas secondary is related to the original work injury, the physical injury. To me, all of that doesn't matter, because either way, the impairment, whatever comes into evidence about the mental impairment is the same. And that seems to be your concern here, that Breen analyzed the burden of proof being different under the primary mental impairment. All of that doesn't matter. It's the resulting impairment that's in the record is the same. And that's where I think we're struggling, is once you have those impairments, what's the important government interest?
You can answer.
Okay. Is creating a cap and a difference between 500 weeks and less, just like a knee pays a little bit more and an ankle pays less, and that has survived.
But those are different injuries. Here, there's no difference.
And it's based on the type of injury. There's an individualized analysis of an elbow's worth this and a shoulder's worth this. Here, we're not doing that individualized analysis for the mental injury. We're just saying, we don't care how bad it is, you're capped at X. Right?
Well, and I think that's, 24B and C will now be treated the same, even though there's not going to be any briefing or any opinion addressing an analysis of B and C. Is the concern.
Well, because you're talking about the proof difference, not the difference in impairment or how correct?
Correct. I'm saying the intent, the protection of statute 52-124 will be undone under the guise of 52-141 and 42.
Okay. Thank you.
Thank you, Your Honor.
Counsel, thank you for your arguments here today and enduring what has been a very hot court this morning. So, Mr. Collins, good job in navigating that. And the court will now be in recess. Thank you.
Sound card, please.